About 10 days ago, I uploaded a video with a string diagram explaining who all the extraneous characters are that are trying to get Turtle Boy thrown in jail, and how Paul O'Keefe is using those characters to make connections between Turtle Boy and Karen Reid in order to get her bail revoked. If you haven't watched that video, now's probably a good time to do it, because I'm going to continue on with the string diagram, so you can better understand why Karen Reid's defence wants to get their hands on Morrissey's private email and private cell phone, and how all that came about. I'll pin the previous video in the description for those who haven't seen it yet. I'll also pin in the description links to Melanie Little's reading of the Betterow letters, which I will mention throughout this video, but I don't need to reread them if somebody else has already read them. And I can't think of a better person for you to go visit and listen to for explanations than Melanie Little, because she actually does understand what each component has to do with the Karen Reid trial. Now, just to tie these things together, let's listen to what David Yannetti said during the hearing the other day.
Your Honor, generally speaking, we do not have an objection to a protective order as long as it is issued without prejudice, which I believe Mr. Brennan is in agreement with.
All right, is there one here? Was there a proposed protective order?
I have it right here, Your Honor. Mr. Brennan printed this to us this morning.
Yeah.
So I have not reviewed that, Your Honor, but I'm asking that the contents be allowed to be shared with the entire defense team, including our attorneys, our interns, and our client. I don't believe Mr. Brennan has an objection to that, but that would be our request with regard to the protective order, with the understanding that we could come back before the court and revisit that if we deem it appropriate.
Is there any objection to the sharing with the
There's no
defense team?
objection to the parties they would like to share it with, and I understand it's without prejudice.
The protection order, I understand, is to impound or seal the documents containing Meatball or D.A. Morrissey's email and text records. Both parties have agreed not to share them anywhere else but amongst the two legal teams, i.e. not publicly.
Okay.
Yes, and with regard to the motion itself, Your Honor, I had come prepared with an argument for the allowance of the motion. Given Mr. Brennan's, the work that he's done in terms of trying to gather this material and get it to us along with the protective order, I assume that there's no general objection to the motion, so I don't need to be heard in that regard, assuming the court would allow the motion. But I would raise an issue for the court, actually two issues. One is that we were informed this morning that Mr. Brennan has gone through Mr. Morrissey's cell phone. Apparently there is one work cell phone and one personal cell phone. Obviously the personal cell phone becomes relevant because he used the personal email address to make an ex parte communication with the court.
I could be wrong here, but it sounds like Bev's actually allowed this motion. Otherwise, I don't understand why Brennan would be going through the materials from Meatball's cell phone and preparing it to hand over to the defence, unless Bev's approved the motion or he knows she's going to.
One concern that we have is that we were told this morning that with regard to Mr. Morrissey's text messages, not the emails, but text messages, apparently they're somehow remarkably set to auto-delete after 30 days.
So we've gone from butt dials to automatically self-destructing text messages. Surprise, surprise. Anyway, since I don't have an iPhone, I did actually check if this is part of the iPhone system or if this is an extra app that you can download. Turns out it is actually part of the iPhone system. But here's the kicker. With iCloud for Messages enabled, any messages deleted from the iPhone are deleted from the cloud as well. And that's because the iCloud is a syncing service. It's meant to sync with your phone. So if you delete something from your phone, the cloud will sync with your phone and it will also delete it from the cloud. So it is unlikely that those text messages that have been deleted would ever be recovered. And that, in turn, is most likely why Bev has already approved the Rule 17 motion to obtain Meatball's communications.
That obviously raises some questions for us, maybe the subject of a future motion, but more immediately, the concern is every day that passes, we're losing text messages from 30 days prior. So, through today, I believe...
They were preserved, Mr. Brennan?
I've been preserving them since I started the task last week. I'll continue to preserve them.
Okay, so that rules out getting any text message, ex parte communications between Meatball and Auntie Bev during the last trial. It doesn't rule out emails, though. But I'm assuming that they had these conversations over the phone anyway.
All right, so that...
Yes, that deals with that issue. So the only remaining issue, Your Honor, is with regard to the searches that Mr. Brennan ordered conducted or conducted himself, he had searched for all emails sent from Michael Morrissey's iCloud personal email to any emails that had a JUD in the suffix of the email address.
Okay. The significance of that is?
The significance is that would supposedly capture any ex parte communications with members of the judiciary or the clerk's office, and I appreciate that effort.
Including you, Auntie Bev. However, I'm guessing by your calm demeanour and lack of sighing annoyedly into the microphone that you're pretty confident you're not going to get implicated.
However, we think we assert that it's insufficient. We believe that searches should be done of his iCloud email for the name Reed, spelled R-E-A-D correctly, or Reed, R-E-E-D, which is how Mr. Morrissey typed it in his ex parte communication with the court. We don't know if he did that for the purpose of avoiding a FOIA request or if he just misspelled my client's name. But we believe there should be a search for both of those spellings. And in addition, we also believe there should be a search of his email address, the personal email address, for the names of the relevant witnesses, and we can give the court a list, for the names of all judges who have sat on this case, in terms of, is there an attempt to communicate with a judge on some type of personal email account, like he used a personal email account. And then also we believe there should be a search for any clerk's office employees for the same reason, both at Stoughton District Court, where this case originated, and this court as well. We have obviously reason not to trust Mr. Morrissey in light of his actions using this personal email account to make an ex parte communication, and we'd ask that a more thorough search be done for these types of communications.
All right, so why don't you continue to talk with Mr. Brennan, and we can have a hearing on this motion if there's anything that you still need.
See? Calm as a cucumber. If there was any potential that she was going to get implicated at all, she'd be annoyed, she'd be breathing heavy into the microphone and cutting him off every other sentence like she usually does. Anyway, let's talk about how we got here. How did Meatball's communications end up in the criminal trial of Karen Reed? Recall, in the last diagram video, I explained how Lindsay Kearney lured Aidan Kearney over to her house with a fake pregnancy test in order to set him up for another crime that would revoke his bail from the witness intimidation charges. That plan was successful. She claimed he assaulted her, and he was thrown in jail for 60 days. While he was in jail, they hatched a new plan to keep him in jail. The night that Kearney claimed Aidan assaulted her, he actually recorded everything that happened, including telling her that he was recording it. Kate Peter, however, got hold of that recording, edited out the part where Aidan said, "I'm recording this," and Kearney said, "Yeah, I know," and then Kate handed that recording over to Tully. Tully then used it in a grand jury to indict Aidan again for wiretapping. That effort was unsuccessful at keeping him in jail for another 60 days. For some unknown reason, the prosecution dropped the charges, and Aidan was set free. The assault charges, however, still remain, and in that case he's entitled to discovery, except Tully messed up, and he handed over a full extraction of Kearney's phone. Arguably, Aidan's defence team is entitled to that, but as we've seen in the Reid case, these MSPs don't usually play by the book, so there was no reason for Aidan's team to assume they would in his case. Surely Tully's kicking himself now because Kearney's phone exposed all of them. The entire plot, from setting Kearney up on Christmas Eve all the way through to the wiretapping plot. There were communications between Kearney, Genduso and Peter, as well as communications indicating contact with Brian Tully and Special Prosecutor Ken Mello, hints of some type of relationship between Kate Peter and Michael Proctor, and a whole bunch of other stuff that indicates perhaps Brady Giglio violations. This is essentially what the first round of Betterow letters addressed. It was a polite lawyer-to-lawyer request for the prosecutor, who is filling in for Mello because apparently he's sick, asking for the relevant materials that were missing and any other materials that are related, and for the voluntary recusal of Mr. Mello from the case. It also makes note that some messages on Kearney's phone do appear to be missing, that Trooper Guarino did indeed delete files from the extraction before it was handed over to defence. There was ever so much more in round 1 of the letters, so I suggest you go over to Melanie's channel and listen to the reading. But they're essentially asking for all evidence related to all of the witnesses in the Karen Reid trial. The second round of Betterow letters addressed Kate Peters as an informant for the MSP. This request was for all of her communications, including a cell phone extraction. This time, Lieutenant John Fanning is dragged into it, as that's who presented Kate Peters' fake recordings to the grand jury. According to Betterow, Miss Kearney's communications with Kate Peter also implicated Paul O'Keefe in yet another setup, where it's alleged the O'Keefes invited Kearney to the courthouse for a hearing in which she'd never attended any hearings beforehand, so they could claim that Aidan had violated the restraining order that Kearney had against him. Kearney also claimed on that same occasion that he keyed her car and posted a photograph of the alleged keying of the car online, which we all very quickly worked out was taken at Christmas, months beforehand. Wah, wah, wah. And that's about where we're up to with the Mass State Police conspiring with all these people that hate Aidan Kearney to get him locked up in jail. Next we move on to the witness intimidation charges. This is where the McAlberts cried victim because people were protesting, and Aidan dared to stick his camera in the faces of the McAlberts to interview them about the Reid case. It turns out that after Meatball engaged Ken Mello to be the special prosecutor of Aidan's case due to a conflict that arose, Meatball went ahead and launched another investigation where he asked the Mass State Police to search Aidan's cell phone, while Mr. Mello was actually in court claiming that they couldn't search Aidan's cell phone. Not only could they, but they actually did. And then they used it as evidence in one of Karen Reid's pre-trial motions to prove that she had some kind of contact with Aidan Kearney. Fortunately, they were unable to make the connection that they were looking for, the one that would prove that Karen Reid had ordered Turtle Boy to go and put his camera in the faces of the McAlberts and ask them questions for his news website. If they were able to prove it, it would amount to third-party contact with witnesses, and that would be a violation of her bond conditions. It would be this part of Team Aidan Kearney's investigations where they would uncover Meatball's communications with judges involved with Aidan Kearney's cases via his burner phone and his burner email accounts. The irony is, had they not conspired against Aidan Kearney in order to specifically tie him to Karen Read, and then produce hundreds of pages of documents in Karen Read's case trying to make those connections, then neither Karen nor Aidan would be able to use each other's evidence in their own trials. In so many ways, they have cut their own noses off to spite their faces. But it's okay, folks, because Auntie Bev's not going to get implicated, so she'll throw them all under the bus. At least that's what I'm thinking after the last motions hearing. In fact, if I had to guess, I would say Meatball is targeting Mr. and Mrs. Read specifically out of vengeance because he's been targeted. He's too stupid to work out that it's his own little conspiracy angles that he's been working all this time that have come back to haunt him. He literally did this to himself, and it doesn't look like Auntie Bev's gonna save him. It sounds to me an awful lot like Bev's ridden the Meatball gravy train as far as she can ride it. Of course, I could be wrong. We could find that next trial she's got a head up her ass again and deep-throating the microphone as per usual. But it is a cool thought and a little bit more uplifting than our usual thoughts about Auntie Bev. Anyway, I hope this was informative for people who are still confused about how all this extraneous stuff ties into the Karen Read case, and leaves you all with at least a momentary smile on your face thinking that maybe Bev's going to throw everybody under the bus.